case number D500910, Jensen versus Jensen. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Vallarino, bar number 517. I'm present and appearing with Caroline Jensen by video conference.
Sabrina Dolson, bar number 13105, appearing on behalf of the defendant, Shane Jensen, who is also present via video conference.
All right, Ms. Dolson, I do want to commend you on doing one thing, and that is reminding the court about how, if this goes forward in front of me, what the procedure has to be. You pointed out in your notice to the Supreme Court that Ms. Vaccarino might be withdrawing her motion, which has already been ruled upon. So you are correct that it wouldn't be a simple withdrawal of the motion. Rather, the parties would have to stipulate to set aside the order granting the motion and stipulate to a withdrawal of the motion before you could proceed. So that gave me a little, light bulb and said, yeah, she's right. But the question is, where is this going?
We are still in communications with opposing counsel regarding. We are still in communication with opposing counsel regarding settling the matter. So we haven't reached a decision, but we are here just to request that the court set a hearing on the motion to set aside in the event that we're not able to settle the underlying issues.
Ms. Vaccarino?
Your Honor, Caroline requested that she be heard and we have a brief oral argument upon the motion, which has not occurred yet, if the court please.
I'm not going to hear from the parties. They have attorneys.
What we would request, Your Honor, is you have read the report to the Supreme Court. I have read it as well. It is clear to me that where we're all in agreement today, it doesn't look like it will settle because the requests are they're just not going to settle it, probably. We've tried for 3 years. However, because we're not just talking about the disqualification issues, other issues were brought in.
That's only we're talking about. We're not talking about any underlying motions today.
I understand. However, that has not been possible. I can't disclose to you because it's privileged. However, Your Honor, one thing that's clear from the report.
Right there. I think it's our sound because their sound is fine, but it's so low. Can we increase their sound?
No.
Please.
I can't, Judge.
You can't take it past 40?
No, I can move it up a little bit, but
all right.
We have to be careful for the feedback on the record.
Let's try that again. Okay, start over, Ms. Vaccarino.
Thank you, Your Honor. What the report says to the Supreme Court is Shane's motion for fraud. He asked the Supreme Court to not wait for you to hear that in November. Shane, and we agree, that's where we all agree, that motion for fraud, we'd like to argue it first. However, the Supreme Court told us 2 weeks ago that they are ready. They will soon. They know it's been a long time with COVID, everything else, 6 months. One thing they told us is they are ready to rule on those issues that predated this motion, which we think is legally doesn't have a prima facie case for fraud under Blanchard. So what we're asking you today is take a closer look at that report and see that where we are in accord today is that we would like the Supreme Court to finish its business ASAP and to get a decision one way or the other. But before that, Your Honor, we'd like to argue whether or not this should proceed. This present motion file, it's a very huge standard, clear and convincing evidence, 4-prong test under Blanchard. And we'd like 5 minutes to 10 minutes maximum to argue what I've cited very clearly in the brief for page 8 especially to 9 cites the 4-prong standard that's extremely high. You don't only just allege intentional misrepresentation.
Page 8 of what? What are you talking about?
I'm sorry, Your Honor, my opposition and counter motion filed May 8th. So we would like the opportunity before you rule on scheduling another trial to reopen these proceedings that this motion doesn't meet that high burden that's been filed by Shane Jensen. You have to show that the other party made a false representation, number one. Number two, with knowledge of belief of falseness. Number three, intended to induce Shane to act or refrain. Number four, that Shane justifiably relied and was damaged. Justifiable reliance requires that the false representation, in or about July was the order, must have played a material and substantial part in leading Shane to adopt his particular course in opposing the disqualification of his counsel.
This isn't a motion regarding
fraud, to set aside a judgment.
Just fraud upon Mr. Jensen. It's also tantamount to alleging fraud to the court.
It's a high burden, exactly. And the court added, you have to show that it played a material and substantial part in his particular course. So look at your decision. It says, in or about July 2014. It doesn't say on July 2nd. And then you'll see the adoption of offers of proof attached, that Caroline did find another letter where she asked Shane. It's attached as our Exhibit 3. And it says, I need advice from Bob, and I need his phone number. So what you're saying that we were just asking, Your Honor, if you're going to grant open proceedings, not grant the motion, to decide if you're granting the motion, that you make findings under Blanchard that he can prove that her using the alleged date of July 2nd, or all of them mistakenly thinking that's the date the discussion had, isn't in accordance with your decision that says not July 2nd, but in or about July 2014, and that makes the whole decision wrong? No. Fraud on the court is if they found a doctored up medical record for a child in a custody case, and he found it later. Even then, you're supposed to bring it to court at trial. But this is not fraud upon the court. This is an innocent mistake, and he could never prove that she said July 2nd and everybody else did to cause a fraud and cause you to, totally discount her testimony. I mean, it's a huge standard, Your Honor. So we're just asking that we have that opportunity, and you also allow us to tell you that it's very ironic that this whole issue that Caroline asked for advice from Bob Dickerson in or about early the first week or the second week of July 2014 was about Shane Jensen's fraud. He had 13 counts of larceny against him, and he had 15, he got a dishonorable military release, and he lost his retirement. She testified about that at trial, and then he took out after he lost his retirement and he lost his right to stay in the military dishonorably, he took out 13 credit cards in Caroline's name 5 days after Finn was born, almost 11 years ago. So what we're saying is, the bottom line is, Your Honor, it's so ironic that the person the exact issue that we were talking about to get information from Bob was about the issue of Shane's fraud, and today he's trying to pull a fast one with the court saying she lied about a date in question because she thought she was at an air show the next week. He should have found that evidence before, and she would have corrected herself at the time on the stand. So, again, Your Honor, before you open these proceedings, beware that he doesn't really care about his motion for fraud. He thinks he's going to win his writ, and they're ready to rule on it. And why should the Supreme Court be delayed 5 more months? This is not a case for fraud. There's other cases cited, 12 other cases, Kramer, Savage, Salsom, Ochioto, Hazel, Atlas. I've cited them all throughout, including through page 12, Your Honor, but Blanchard is a family law case, and it's really on point. So you don't see anywhere in his declaration an offer of proof that Caroline did this, because she said or did this, it caused me to do or say that, and therefore you were totally misled by the fraud Caroline, who had a 22-year impeccable military career, and she recently retired when she could have stayed in and made general. But that's a choice that she made, just like he did. He started making. So I'm saying to you, Your Honor,
in front of me, Ms. Vaccarino,
okay,
and raised by the defendant, is the issue of whether or not I should set aside my order of disqualification based upon alleged fraudulent misrepresentations by the plaintiff. I find that there is sufficient cause to hear that issue to determine whether I should set aside that order. Now, it may well be that the Supreme Court is ready to rule, but I'm guessing that if I say I'm going to set ahead an evidentiary hearing to reopen this issue, that they will hold off. What I was hoping, frankly, counsel, all of you, and parties, both of you, was that you would come up with a solution to send it back so that we can address the issues that were raised in the underlying motion. And I will warn you, Ms. Vaccarino, the issues you've raised in the underlying motion are not necessarily a slam dunk. That would require itself an evidentiary hearing to determine whether or not your motion regarding child support in custody is meritorious. Okay? So, I don't even get to that until I know who is representing the defendant, who is entitled to have counsel with him on your underlying motion. Insofar as the defendant has alleged that I was misled intentionally, I think that I would abuse my discretion not affording him the opportunity to prove it. He may not be able to prove it. I may agree with you ultimately, Ms. Vaccarino, but I would have to hear the evidence, because it really boils down to a single question. Did the plaintiff have a conversation with Mr. Dickerson outside of any joint conversation with both parties that would have obligated him to provide the opportunity to the plaintiff to waive confidentiality? Okay? It's a real simple issue. But it's not so simple if, in fact, this was manufactured out of whole cloth. And I don't know the answer to the question. You all have spent a whole lot of money, and I appreciate, Ms. Vaccarino, your frustration. I'm not much less frustrated. But I have an obligation to the truth and to determine what is the proper proceeding in this case. Should Mr. Jensen keep his attorneys? If, in fact, I was misled intentionally by the plaintiff, then yes, I may consider him entitled to keep his lawyers. And I appreciate that this matter has gone up to the Supreme Court and would have stayed with the Supreme Court, frankly, but for this motion. And Ms. Dolson knows that. But I have an obligation to make sure that I did rule on proper evidence. It's as simple as that. And I was really hopeful that the parties would come up with a mechanism whereby they aren't giving up their positions on anything else, including attorney's fees, but could get this back down to me so I could decide on the underlying motion. That apparently is not going to happen, because it would require a stipulation that A, the parties agree that my order of disqualification be set aside, that upon setting that aside, that the plaintiff withdraws her motion to disqualify, and the parties then tell the court, petition the court to dismiss this petition. Then it all comes back to me. They have reservation of rights. Just because the defendant has reserved his rights to seek attorney's fees associated with his petition doesn't mean I'm going to grant them. It just means he's reserving his right to raise them as a means of relief. It's as simple as that. And I will warn you, counsel, this case is super complicated, because what are we going to do at the end of defendant's time with the child? Where's the child going? I don't know. I haven't permitted the child to relocate out of the state of Nevada. I don't know where he's going. I haven't even been asked to permit him to do that. So, I thought that rather than everybody being super, super, super stubborn, that you would come back to a solution where you can get to the point of addressing all these issues before they become a real, real impediment to the party's son. Now, that apparently did not happen in the week I gave you. So, insofar as the authority to do so, I'm going to go ahead and set an evidentiary hearing on this motion. I assure you that the likelihood, under these circumstances, that I will be trying the underlying motion is extremely remote. With just the passage of time and the number of cases where people have asked me to get them in for their trials, for their hearings, before the end of this year, I'm getting real backed up. So I thought maybe the parties simply want me to address the issues they raised a couple of years ago, and as well as raise the issue of where this boy is going to be living during the school year. But no, heaven forbid. So, let's get you a hearing date. And Ms. Golson, you can notify the court that I've set a hearing on whether or not I should set aside my order of disqualification. At that point, the Supreme Court simply has no option. They won't want to rule. Because it would make no sense. They're not going to rule on something that might become moot.
I'll notify the Your Honor.
Yes, Ms. Golson.
I'll notify the Supreme Court.
Yeah. All right, so do you need more than half a day? I don't think you do.
I don't think so. I think half a day would be fine.
Do you need time for discovery and so on?
Your Honor,
Do you need time for discovery?
Just-
I don't see how.
well, technically there were new papers attached to both parties, the motion and the opposition. We've already done all the discovery, so I wanted to ask you, we've had a few days of trial on this in July and September of 19. So your parameters, I would urge the court to please say, it's my understanding that you'll want to hear from Shane, Caroline, and Bob only again, because it's the issue that's been alleged is only that she lied about the date that this happened. That's what's alleged, that she lied about the date, so she lied about everything else. So I just want to be clear, if we're taking a half hour, that's a half day, that should be plenty of time, but that's what, just like a regular trial, I just want to manage the evidence that you want
Well, you know
to hear,
what?
please not.
If you are efficient with your examination and with your presentation of the evidence, it's a narrow issue.
I agree. So I just want to, that's why I think we don't need to reopen discovery, and what's been attached will be the new documents for you,
We'll
unless
give
the
you a
court.
date in September.
Please. Oh, you have a date in September, Your Honor?
No.
Yeah. No?
No.
Thank. No,
Maybe
I
that's
thought you said
September?
November last
No.
year.
Counsel,
This is what I'm talking about, counsel. Go ahead.
the earliest date we have is Thursday, October 15th at 1:30.
It is altogether possible, if not probable, that we will be doing this hearing remotely, like we're doing this hearing today. I realize the limitations on my ability to evaluate things like body language and everything else, but I don't see that we have an option to do otherwise. You have between now and October 15th, I'm not going to require briefs, I'm just going to require your moving papers. But you have now a couple of months to really make a decision as to where you want to go. Now, I will make one observation. This is directed at the parties. You two have been in litigation for a very long time. You both earn a nice living. Not that much. You are spending an incredible amount of money that could be used for, I don't know, college for this boy. Flying lessons maybe, because he kind of comes from a family of pilots. You know, all kinds of wonderful things that you don't have the money for because you owe your lawyers. Or you could decide, you know what? We just want the merits. We just want the merits. We just want to cut to the chase. We know that lawyers like to lawyer, and I understand. You know, I spent 27 years as an attorney, a trial attorney myself. We do tend to lawyer, okay? But I'm looking at this case as a larger picture. And the larger picture is about two people that had a relatively unpleasant divorce from each other. Post-divorce, they let it continue. Their son knows that his parents are hostile toward each other. Boy, he's a lucky boy. He's also, by the way, parties dealing with the uncertainties of a pandemic. He watches TV because his parents probably have it on. He knows he might not really go back to school in the usual sense. He hasn't been seeing his friends. Everything's changed. His parents' work has changed. You know, the defendant flies long haul, I understand. I'm not sure what long haul is these days, considering we're shut out of a bunch of countries. So everything is so chaotic and erratic and scary for a kid that I am concerned that these parties, and he's 11, he's just 11, he's going to be 12, okay? You know what that means? Not only is he dealing as a child with a pandemic over which he has no control, not only does he have to deal with the fact that his parents are hostile to each other, a matter over which he has no control, not only is he dealing with he doesn't even know what kind of education he's going to get, but let's add to the fact that I give him a very short period of time before he starts puberty, if he hasn't already. And we all know the emotional impact that puberty has on an adolescent's brain. It's chaotic. So, what I was hoping you were going to tell me today is that we could get to the underlying motions, not because the parties, you know, don't want to fight anymore, or this or that, or, you know, they want to get their point across, but because there's this person that is being left out of the mix, and his name is Finn. None of this is about Finn. Nothing here is about Finn. Shame on you. Nothing is about Finn. And look what you're putting him through. So, we'll stick to the lawyering. Unless the parties decide how much they love their boy, that they don't want to put him through this anymore. Because he knows stuff is going on. He's might not even be entirely sure where he's living come the school year. But let's all keep up with the lawyering, because gosh, that should be in his best interest, but it's not. It's not. So, I'll see you in October, unless you really sit down and figure out what's really, really important. And I'm telling you, parties, you need to sit down and figure out what's important. If it means you have a pleasant, respectful, and kind conversation with each other, you should do that. Because Finn isn't about money. It's all about getting him to grow up to be strong and powerful and successful, and nobody's victim and nobody's bully. I say this all the time, because I will tell you that kids whose parents don't get along generally tend to be a lot weaker than kids whose parents are kind to each other and figure out solutions to difficult problems. That has not happened here. This case, Ms. Vaccarino, if we agree on one thing, we agree that this case has gone way off the rails. But what I don't think the parties understand is how much it's impacting their child. I would assume that you want to revolve your lives around Finn's, not making him revolve his life around the two of you. I've said my piece. I'm very sad for Finn. And I'll see you in October unless you figure this out.
Your Honor, just as a matter of procedure, because you've mentioned twice the relocation of the child, we are going to have to, if we don't get an answer from the Supreme Court soon, we're going to have to file a motion to ask that you address the issue of interpreting the July 15 order, which we believe already provides express consent to further relocate from this state. Dad's not in the state, Mom's not in the state, and he has summer visitation. He already has extremely generous alternate visitation. And I might file a motion for summary judgment because the timeshare in text messages and all the discovery exchange shows that they agree upon what they've been sharing, so under Rivero, all that's left is money. What I'm saying is this right to Nevada Council issue is going to become moot. He lives in Washington.
I appreciate that I addressed my comments to the parties, but clearly you weren't listening either.
Well, no, I'm just saying to you, Your Honor, I don't want to step. We have to have a legal order that clarifies the exchange. It clarifies that she could have moved, in our opinion, but right now it says the exchanges take place between Washington and Nevada, and he moved.
Go do your lawyering.
All right, I'll file a motion because that's what we're going to do, so you can clarify our understanding.
Ms. Vaccarino,
I'll address it with Ms.
Talk to your client. Talk to Ms. Dolson before
the problem
you
I have
file
is
your
this:
motion.
they're disqualified. They're disqualified on the underlying issues.
To think about what they're doing.
They're disqualified as counsel on the underlying issues, but they're not disqualified as counsel on the disqualification issue. So I'm kind of in a quandary because I have an issue where I'm kind of stayed on doing anything, including confirming exchange.
Ms. Vaccarino, go do your lawyering.
I'll figure it out. Thank you very much. I appreciate
it. I'll see you in October.
Thanks.
Thank you.
Yeah.
Oh, wait. Get her back on.
Oh, shoot.
Sorry.
Okay, John, can you call her?
John, get her back on.
And Ms. Dolson, defendant left too, but as long as you're in, no, there he is, okay. I'm gonna go off the record for a second.